Getting beat up by spreadsheets in your brewery? Don't let those dumb pivot tables bully you around. Get rid of the spreadsheets and the other clunky brewery software and get Ollie, the smart and affordable way to manage your brewery. Learn more at getollie.com.
All right. Good afternoon, everyone. My name is Megan Farley. I'm a partner at Allen Stoll & Kilbourne here in beautiful Asheville, North Carolina. I've been with the firm for a little over 9 years now and focus my practice on business law, trademarks, and craft beverage law. Joining me today is Allison Kinnear, and I'll let her tell you a bit about herself and her practice.
Hi, everyone. I'm Allison Kinnear. I joined the firm in June after 25 years of practicing law in Denver and moved to Asheville to be near my family. My business practice focuses on corporate governance, contracts, due diligence, restructuring, and really what we're here to talk about today is raising capital the right way and structuring your exit. So I have to give a disclaimer that's here on our first slide. This presentation is for informational purposes only and does not constitute legal advice. Participation in this presentation does not create an attorney-client relationship. We do not represent you unless and until a formal engagement agreement has been signed. So with that, we will go on to our presentation. And this is a serious topic, so I hope we haven't caught you at nap time.
All right, so as a quick overview, today we're going to talk about the different types of funding sources for growing your business and all of the nuances that entails. Some security considerations for those sources of funding and what it takes to put yourself in a good position to sell your business. All right, jumping right in, growing your business. All right, congratulations, you've survived business infancy and now you're ready to grow your business in whatever capacity that means, whether it means buying new brewing equipment, adding a beer garden, adding your own canning line, adding new locations, whatever that means to you. Well, how do you do that? Well, it typically means you need more money. How do you get more money? Well, there's a handful of different ways that we're going to discuss that you can get some additional funding. So traditional funding is pretty much what you think of when you think about getting a loan. It's going to a bank or your local credit union and applying with that financial institution for a loan. Another avenue for traditional funding, which I didn't put here, but it can include nonprofit lenders. We have one here in Western North Carolina that a lot of our local businesses use for loans. So this is another good source for finding funding if you have one of those local to you. Another way to get additional funding is to get it from your current owners. So it's important to note that a loan is not a capital contribution, which some people kind of get confused. But a capital contribution would increase their ownership percentage. That's not what happens here. A loan is just like what you'd get with a traditional lender. In this instance, the owner lender will get paid back on the loan over time with interest and all the other sort of standard promissory note terms and conditions. You can also do a capital call, which requires the current owners to contribute additional equity into the company. And I'll discuss that in a bit more detail in a few slides.
And it's also possible that you could have a buy-sell agreement that you entered into at some point during your growth, whether it was at the outset or later on, something that provides for what happens in case an owner becomes disabled or dies, or some sort of life-triggering event, typically a divorce, a bankruptcy, or just someone wants out and there's a right of first refusal of the company. So there's a lot of ways that the funding arrangements among owners might change.
You can also go get a third-party loan. This is when you have individuals or non-financial institution businesses that loan your business funds via a promissory note. Again, this is just a loan. It's not a capital contribution. They aren't giving you money in exchange for equity in the business. They might require a certain percentage of interest or shares if you're a corporation as collateral, so that in the event you default on the loan, they may become part owner in the business. But otherwise, this works similarly to a traditional loan, with the added complication of this potentially being a securities transaction, which Allison will go over in much more detail if the ownership interests or shares are used as collateral. And then finally, one of the more common ways to get funds when you don't need a lot of money is from outside investors. You can also, if you need a lot of money, the venture capital funds can provide that. But these are typically your friends and family, or the friends of your friends and family, and just your extended network, angel investors and venture capital funds. And these group of folks expect to obtain an ownership interest in the business in exchange for their giving you money. There are pros and cons to each of these types of funding. You really need to weigh all of your options with your CPA, and that your CPA will help you understand which might be the best option for you in this period of your business's existence. For traditional lending through a financial institution, you can get bigger loans. They're exempt from securities transactions, so you don't have to worry about all of the filings and notices and information production that goes on with those. They can provide you with ongoing support. They have experienced staff and a significant amount of resources, and you don't have to give up any of the equity in your business. Your ownership stays what you currently have. On the other hand, you have little negotiating power on the terms of the documents, like interest, who is and is not a guarantor, what is or is not collateral. It can be a very lengthy underwriting process, sometimes taking several months. And this can be very frustrating when you have an exciting new project that you're ready to get started with. And they very often require personal guarantees, which means that if the business falters and it can't pay the loan back, then you and your personal assets are all of a sudden on the line to pay back those loans. For individual lenders or investors, you typically have more negotiating power on the terms and conditions of the loans, and you can get the deal turned around faster because you don't have the amount of underwriting that the institutional lenders will have to have. However, you are probably limited to smaller loans, and you may be looking at a securities transaction if equity is used as collateral. All right, so digging deeper into capital calls, as mentioned previously, this is when you request additional capital contributions or additional funds from the current owners. This type of funding typically starts when the managers of the company or the members get together and decide how much money they need to fund their upcoming project. Once they decide that, they issue a capital call notice, letting all of the current owners know how much they intend to raise, the pro rata amount that is due from that particular shareholder or interest owner, and the date by which those funds are due. You'll have to read the terms of your operating agreement or shareholder agreement to see what kind of terms and conditions or consequences there are for each of the owners regarding capital calls. They kind of run the gamut. So some of them don't require interest owners or shareholders to pay any additional capital into the company, but failure to do so may result in the dilution of your ownership percentage. Some of them can require that you pay, and if you don't, it triggers a buy-sell event. This one's kind of harsh, and I don't see it a lot, but I have seen it. Some just say that if you don't pay, you lose your voting rights in the company, in addition to having your ownership diluted. So again, these kind of run the gamut. If another interest owner picks up your pro rata share because you can't afford to pay the additional amount, then that amount is added to their ownership interest. So for example, if you have a 5% interest in the business but can only afford to pay 2% and they cover the other 3%, well, then their interest in the business goes up 3% and yours goes down to that 2%, or by that 2%. Capital calls can be, to just go back real quick, they can be a bit touchy for some of the current owners who are probably your friends and family or close network, because that's a very common funding source to get many businesses up off the ground. And that can cause some of them to get kind of upset. Usually it's just the ones who can't afford to pay, because then they're going to lose some kind of benefit. Usually they're going to be diluted, or sometimes they can get kicked out. So rather than impacting those close relationships, by forcing, friends and family in your close network to pay more money in, then some business owners will elect to go to one of the other funding routes just to prevent that kind of tension among the current owners. And if you've tapped your friends and family network for as much as they can give, you're going to have to start looking outside of that close group of funds. And that's where these outsider investors come in. This is typically the networks of your friends and families, but it can also involve or include angel investors or venture capital funds that fund your growth projects. If they fund it through a promissory note, that's simply debt taken on by the company that gets paid back per the terms of the note. It's going to act just like a loan with the financial institution. If they come, if they pay the company funds with the expectation of getting equity in return in the company, then that's a capital contribution, and you have a new owner, and everyone that is a current owner will get diluted pro rata to the amount of newly contributed funds. As mentioned earlier, in some instances, you can start out with a promissory note, and if the ownership interest or the shares were used as collateral and the company defaults on the loan, then the remaining balance of the loan can be converted into capital. And all of a sudden you have a new owner that you may not really want. And you may have implicated securities law. So you have to be kind of careful with these and the wording of the documents that you sign when you do this type of funding. Do you need a valuation? You can get a valuation a couple different ways, usually through an appraisal or through a CPA. The only truly accurate way to know the value of your company is through an appraisal, but they can be pretty expensive. If you get a traditional loan, the lender will want to have, they want to value the collateral. So they're going to likely get an appraisal, and the cost of that appraisal will be included as part of the closing costs of the loan. And they will want to do this just to ensure that the collateral they use to secure the debt, if sold, would cover the entire balance of the loan should you default on it. And I'm sure you all understand this, but just for example, if you need a $2 million loan and the appraisal shows that your equipment being used as collateral is only worth $1.5 million, then the bank will either not give you the loan or they will require additional collateral. On the other hand, if the appraisal comes back at $2 million or more, you're fine and you probably got the loan. For other investors, this kind of runs the gamut regarding what they want to see and value. More sophisticated investors will want everything. They'll want a valuation because it will accurately determine what percentage ownership or the number of shares that they will receive in exchange for the money they put in. Again, they can be expensive, but they're not necessarily a bad thing to consider doing, as they can stop issues down the road where you have someone, claims someone paid too much or they got too much equity in the company, and you end up in profit sharing battles. So it's good to get those just to sort of avoid some of those in the future. They're also helpful for taxes, succession planning, and exit strategies.
Sometimes our smaller clients will do internal valuations with their CPA and establish, either with their board or their managers, a value that they negotiate with outside investors. The real trick is that the company has to bring everyone in at the same time at the same value, which just can make it a challenging journey in the negotiations. But we'll get to that in a minute.
All right. So people and financial institutions, they don't like losing money. So if you're going to ask people for money, you're going to have to expect that they're going to ask for a lot of information and documentation from you. So that make sure that they're making a good investment or a good loan. And I won't go through this list, but here are a handful of items that are typically asked for. For institutional lenders, as the borrower, you would expect to provide them with documents like the last 2 to 3 years of tax returns, profits and loss statements, cash flow statements, balance sheets, your operational and organizational documents like your articles of organization or incorporation, bylaws, shareholders agreement, operating agreement, leases, and the like. They're going to use their forms, and you're not going to be able to change them very much, if at all. The documents that you might expect to have to sign as part of the loan package would be the promissory note, deeds of trust, where deed of trust stays. So if you're in a mortgage state, maybe a mortgage, guarantee agreement, assignment of rents and leases, security or collateral agreements. And you should expect that they will file a UCC financing statement on any equipment. And don't forget guarantors. If the lender requires any guarantors, then they will also be required to provide information as well. The bank will get a credit report. They'll usually ask for income tax returns for a handful of years, usually the same as the borrower, 2 to 3 years. And then they'll ask for a personal financial statement. That's usually on the bank's form. It is different between bank to bank, but it's a detailed account of your assets, your liabilities, and your net worth.
So when it comes to private sources, you're going to work with your counsel to prepare the documents, and with your advisor to go out and find those private investors' private sources. Typically, those would include a teaser and pitch deck, moving on to an offering memo, executive summary, and then the agreements that bring the investor in, subscription agreements, deal documents, and investor questionnaire. And that brings us to really looking at what Megan alluded to earlier, that when you do raise money, if you're not working with an institutional lender, you're likely going to implicate securities laws that you've never thought about. So one of the things that you've done perhaps in forming your company is brought in money from your friends and family, and those were securities law transactions. So what is a security? Why am I talking about this? Anytime you take money from someone and give them an ownership interest in your company or a debt interest in your company, you have a security. It's defined very broadly: units, shares, notes, stocks, investment contracts, options, and more. And what you're looking for is whether the person who gave you money is actively involved or passively involved. And there are some nuances to that, because even bringing in one new owner who might be actively involved could have securities law implications. So it doesn't really matter what you call it. If they are a passive investor with an expectation of profit, it's a common enterprise, then you've got a security, and you need to think about what to do with that. So the reason you should care about whether something's a security or not is because state and federal laws govern these transactions, and compliance is important. And it's not just for public companies, it's for small privately held companies as well. So if you have private investors, those are private placement offerings, and you comply with securities laws so that you avoid all the downside of not complying: fines, lawsuits, enforcement actions. And really, compliance isn't that hard. People often shy away from compliance. They say it's going to take a long time. They say it's going to be a lot of documents. And but really, the kind of information that you're going to be asked to provide people is the kind that builds trust with your investors and protects relationships. So not only does it make sure what you're doing is legal, it opens the doors for the future, and it builds that trust. And compliance is simpler than you think. Businesses of all sizes can raise money through private placements, and the disclosures are not that hard. The most common path is Section 4.2 of the Securities Act of 1933, and Regulation D is a safe harbor for that. And I put accredited investors here in red just because it's really important when you go out to raise money from people that you look at the potential investor and you take the steps to evaluate whether this is a suitable investment for them, meaning you've given them as much information as possible and they still decide to invest, and that they can risk losing it all. So you want accredited investors, and I'll get to that a little bit more in a second. But the disclosures are important because if you can't make the disclosures about why you're taking people's money, who you are, what you're planning to do with it, what's your competition, why it's a good idea, and what the risks are involved, you probably shouldn't be raising money. So I have this note here. Just remember, equity should be issued by the company. If the company takes in the money, the company issues the debt or the equity instrument involved, not the owners that already exist. That would be them selling things and taking the money personally. So let's stick with the company, talk to your counsel, talk to your advisors, find the exemptions, and make the disclosures. I mentioned accredited investors. Accredited investors are the type of people that we have decided from a regulatory perspective can take these risks. And you can go online and you can use your favorite search engine and you can say current accredited investor standards. And what you're going to find is that people with a net worth of over $1 million, individually or jointly with their spouse, are accredited. Individuals with income exceeding 200,000, certain professionals with professional licenses, financial institutions, family offices. None of this should come as a surprise. The nice thing about accredited investors, they don't require as high a threshold of disclosure, but they also are the kind of people who can afford to lose their money and are less likely to come after you if you do lose their money. So when you go to do an offering, and that's what you're doing what's called a securities offering or a private placement, we recommend that you get help, work with securities law counsel, do it right, create a paper trail. You're going to be entering into an agreement with every investor, and make the filings that are required by the state and federal government. These laws that govern securities law transactions, they came about during the Depression. And the idea is they're supposed to protect the consumer, making sure the consumer has the information and that you've told the government what you're doing. So reach out to the people who do these things, and we'll keep it simple.
All right. Now we're to the point where you've grown your business and you're ready to sell. All right, so whether or not you're just looking forward to cashing out on all that hard work or enjoying drinking a beer on the beach in your retirement years, or maybe, starting up your next entrepreneurial enterprise, what you've got to do is sell your business. And we wanted to talk to you about this process because so often someone comes to us who is already so far into the process that they end up more stressed than they should have, and spending more money on attorneys' fees and other fees than they should have had they just started with the right team in place and having all of their ducks in a row to begin with. And when I say so far into the process, I mean they hand us a nearly negotiated or an already signed letter of intent. Now, a lot of terms of an LOI aren't binding, but that doesn't mean that the parties don't tend to think of them as binding and they're unwilling to renegotiate them after that piece of paper is signed. So how do you prevent that? Well, the first big step in doing that is getting the right team in place. And that team is going to be an experienced business attorney. And for you all, one that has knowledge in the ABC world. The other person who's going to be super important and when you're selling your business is a CPA or a financial advisor who has experience assisting their clients with selling their business, and a strong management team in place who can help hold the burden of running a business while you're putting everything in place, because it takes a lot of work. I think some clients don't understand how much work it takes to sell a business. It's more work to buy the business, but it's still a lot of work. Getting all of the paperwork, helping provide all of the documents for the buyer's due diligence, all of that takes a lot of time and effort. And so you want the right management team running your business so that the business doesn't falter and you can focus on doing that to make the transition as seamless as possible.
Well, and when you are ready to sell, you can answer the questions in a way that is streamlined. You've thought through the process, and you're not going to your advisors and saying, this is taking too much time. I've got a business to run. And we touched on this before, getting organized.
Yeah. So the next step is getting organized, because the buyer is going to ask you for a laundry list of documentation as part of their due diligence. You're going to want to have all of your organizational, operational documents handy and ready to help, hand over. You're going to need to get with your CPA to get all those financial records. You're going to want to have all of your key contacts or contracts. Think vendor contracts, customer contracts, lease agreements, loan agreements, that sort of thing. Have your HR information handy, and make sure your annual reports, or whatever you call it in your state, are up to date with the Secretary of State. You'd be surprised at how often we get a seller client who's missed one or more of their annual reports, or even has gotten a notice of grounds to administratively dissolve their entity. And so we end up having to file those to bring them back into good standing, because the buyer's going to want to know that they're buying a business or the assets in good standing. And then for you all as brewers, you're going to need to get with your attorney in your state to know what you need to do to transfer or terminate your ABC permits. In North Carolina, ABC permits don't transfer. So it's important to know that, so you don't try to negotiate transferring permits when you can't legally do so. I have actually had a client to do that one time. Well, you can't do that. It's the same with your TTD permits. Just know what you need to do with those in advance, so that you don't get in trouble with any filings or any short deadlines that they may have.
Well, and one of the things that I've seen clients do when they're getting organized is they get a business broker advisor involved who starts asking for all these documents, and they end up feeling pretty burnt out just from that first stage process before you get to the rest of the deal. So one thing word of caution is, if you use a business broker and you don't have legal counsel involved up front, when legal counsel gets involved and you found that buyer, you might feel like you're going through it for a second time, because there's a whole different set of questions that are going to be asked, another set of documents to be produced. So the more organized you are up front, the more you prevent that burnout.
And also, if you involve us there in the beginning, we can work with the business broker. So you're providing all of that to both of us at the same time. Yeah, good point. So I think this kind of goes without saying, but if you want someone to buy your brewery, it needs to be worth buying. And you prove that through the documentation that you give to the potential buyer by showing, the stability of the brewery, its profitability. And this is part of their due diligence, but that you are in a market that has strong growth potential. All right, this part is pretty important. So if there's a handful of things you take away, let this be one of them. Because we get a lot of folks who don't understand how to answer this question when we ask them. And that's, what kind of a deal do you want to do? Do you want it to be an asset sale, or do you want it to be the sale of the ownership in your business? And one of my recent deals, the parties literally changed their mind in the middle of the deal and ended up having to pay a lot more than they should have if they had just done their due diligence and gotten their sale team together in the beginning, talked to their attorneys and their CPAs before they reached a deal between themselves that just was not going to work. So there are, like I said, two types of deals. We have an asset sale, and then we have the sale of the ownership of the business. To talk about the asset sale first, this is the sale of what I like to say, the stuff that makes up your business. This is the furniture, the inventory, the supplies. For a brewery, that would include the brewing equipment, the canning equipment, kegs, and so on. But it also includes the intellectual property. A lot of people don't think about that, but that has value too. The trademarks and the trade secrets that are so important to your business. The logo, the names of your beers, the recipes and formulas for your beers, the goodwill that you've developed locally, regionally, or nationally. Because again, there's value to that, that you can sell the intellectual property to a buyer. In an asset sale, the buyer creates a new entity, and the assets transfer ownership from the seller company to the buyer company, so that there's nothing left in the seller company. And it typically, and it's just a shell at this point, it just winds down and dissolves. Note that the company owns the assets. So the funds from the sale are paid to the company, not an individual owner. And after all of the liabilities are paid as part of the winding down process, whatever remains is distributed pro rata to each owner. Excuse me. On the other side of the coin, you have a membership interest or a membership unit or a stock purchase of the ownership in the company. Here, the buyer is buying the ownership in the business, not its assets. There is no new entity. The buyer is stepping into the seller's shoes, and everything else stays the same. Because membership interests and shares are personal property, the proceeds from this type of sale go to the individual owner, not the company.
And so really, I mean, when you're doing the diligence on yourself, which you should be doing before you open up your files to someone else, you're going to be analyzing your deal types, talking to your CPA, your legal counsel, looking at the tax implications. And one of the things you'll probably hear a lot of is that an asset sale is more flexible because you can hold on to certain assets you don't want to sell. Occasionally, I've seen artwork that the company owned, vehicles that the company owned. It also gives the buyer an opportunity to not take along what they consider a loser asset. So, but it's all a negotiation. And then when we're looking at outside investment, the sources for outside investment could be additional owners and operators coming in, taking a portion of the business. They could be a strategic investor also coming in and just taking a portion of the business. Maybe they're a strategic bringing in a product line. Maybe they are allowing current owners to take the chips off the table. Maybe they're bringing a network, a distribution channel. Maybe they've been a small investor and they're taking a larger stake. In that case, you typically have current owners and management staying in the management and operations. Just remember, though, that I'm going to say it again, equity comes from the company, not individual investors. If the company needs to make money, then the company is going to be the one to make the sale. And sometimes those outside investors ask for some pretty preferential terms when making those investments, decisions that they control going forward, with whether it has to do with executives or salaries or contracts or the sale of the company. Those are usually negotiated items in a shareholder or operating agreement context. So who might buy or invest in your business? We've talked about insiders. We've talked about strategic buyers. We've mentioned financial buyers. But how do you find these people? And you find them because you network, you reach out, you interview these people, you find out, have they done deals in your industry? Do they know your strategics? Do they know your industry? Have they done, I did a traffic control company that was rolling up into a company that did a lot of traffic control. So you reach out, but keep in mind that all of these people are going to take a fee, and you need to negotiate those agreements too. And you should get your counsel involved there as well, because they know what those deals should be structured like, how they should be structured, what the market rates are in your industry. And really the fees vary by deal size, industry, market conditions. So you need to negotiate those fee-based advisors deals up front. And then when you go out to the world, I put this in, just be aware, there are rules about generally soliciting and advertising for investors, and you need to make sure you follow those. So what do these people do who help you find a buyer if you can't find one through your network? Well, they prepare your offering documents with the company and counsel. They'll do a non-disclosure agreement typically, so that as you're shopping your company, they're maintaining confidentiality. Often the brokers, advisors, bankers will use what's called a teaser. It's often anonymous. It'll go out saying there's this type of business doing this kind of work with this kind, looking for this kind of multiple, and they'll see what the indications of interest are before they disclose the company information specifically. And then they'll prepare with counsel a confidential information memorandum that can go out to investors. So they approach potential buyers, they do the screening process, they assess the seriousness, the cultural fit, They work with counsel to prepare the letter of intent, and they make sure that the buyer is actually a legitimate buyer. So I mentioned the letter of intent. Ideally, that's where the deal begins. I used to not be a fan of letters of intent. I thought they were maybe a waste of time. Why not jump into the deal? But I've become a fan because having it in writing, what the key deal terms are, negotiating those deal terms up front in an outline framework, it really sets the expectations and ensures that you have a meeting of the minds before you get to the definitive documents. And quite frankly, that saves clients a lot of money. The key deal terms that you're going to negotiate with an investor or in a sale are your structure, your purchase price, your payment terms, how long you have to do that due diligence, that investigation of each other. Make sure that if you're the seller, you're due diligencing the buyer too. I've seen a lot of seller situations where it's not a good fit going forward after the sale for the current management team. Often the selling owner stays on for a period of time. It's not a good cultural fit. So it's important to really make sure you know your buyer. Look at your closing conditions and timelines. Sometimes clients come to us and they say, oh, this will just take a couple months. Nothing takes a couple months. Everything takes at least 90 days, unless you're super lucky, but stick with everything. And then you're going to talk about allocating expenses, governing law, transition services for employees and operations. This is just the beginning, getting you in the mindset of there's this big process and it's fun, it's exciting, it's a lot of work, but the more you're organized and prepared and aware of who the different players are, the better the process goes. So I hope you found this helpful. It's a lot of information to pack into just over 30 minutes. If you need to reach out to us, you have our contact information here. Again, we have not established legal representation, but we would love to hear from you.
Thank you.
Thanks.
Thanks for watching. If you enjoyed this session, we'd love to see you in real life. We host in-person workshops across the country for craft beer professionals just like you that are held in some of the most exciting beer destinations around. These immersive events are designed to help you grow and connect with others. You'll meet peers from across the country and leave with actionable strategies for success. Connection has never been more important, and you can learn more at cbpconnects.com. Cheers. See you there.